Welcome to Cocktail Trending Story. Malema, Julius, the South African firebrand, was sentenced today to 5 years. Cocktail does not have boundaries when it comes to international news. First of all, who is this Malema man? This is a young man born in the year 1981. His father passed on. He grew up under the guidance and tutelage of the mother. He was born in a very, very, very poor background. But from year 9, he joined politics. He became an active member of the African National Congress, the famous political party that brought independence in South Africa. This is the party of the late icon of Africa, the dancing king, Nelson Mandela. He rose to be the president of the African National Congress Youth. After Nelson Mandela left, the president of South Africa, Thabo Mbeki, was not in good books with Malema. Malema supported President Zuma then, who wrestled power through the ANC processes, and Zuma became the president. Later, Malema faced a lot of problems within the party and he was expelled. He formed his own political party. He contested and had around 25 members of parliament elected under his political party. Malema, as we are talking, is a member of parliament. He is a sitting member of parliament. So let us get the historical context to this case. This is a matter that happened a long time ago. That's in 2018. As a leader of economic freedom fighters in South Africa, his party is called Economic Freedom Fighters in South Africa. In 2018, in a rally at a place called Mdanstane, he was seen firing semi-automatic rifles in the air. He was arrested. It was a political rally. He was arrested and charged with unlawful possession of a firearm, unlawful possession of ammunition, discharge of a firearm in a public area, reckless engagement and endangerment to persons or to property. All this in a judgment on October 1st, 2025, he was convicted. He went through the trial, he was convicted. After he was convicted, Malema was given time to do mitigation, and today he was coming for what is called sentence. He has been given 5 years of sentence. 2, has Malema ever had a history of cases in court? Yes. In 2010, he was convicted of an offense of hate speech when he said, he uttered words, "Kill the Boer." In 2012, 2015, Malema was charged with fraud, money laundering, and racketeering. So Malema and the law has been always at the loggerheads all through. What we are concerned about Cocktail is that, and this is where the law is, Malema was sentenced, but he never went to prison. In Kenya, once you are sentenced, what is the procedure in Kenya? Once you are convicted, unlike in South Africa, Malema was convicted in October. He has been outside. In Kenya, once you are convicted, the bail terms and bond terms are cancelled. In South Africa, you are convicted, but you go home. You wait to come to do mitigation. In Kenya, immediately you drive with your Lexus, you drive with your Pajero, you drive with your whichever car. Once the court says you are convicted, the cash bail, the bond that you have is cancelled. That is the first difference between the South African law and the Kenyan law. 2, after you have been sentenced, in Kenya, you go to committee. You go to prison. There is no way you will be released pending appeal by the trial court. If a magistrate convicts you, you will go to the High Court to ask for bail pending appeal. If you are charged with the offense of murder and you are tried at the High Court and you are convicted, you cannot ask the same judge or the same magistrate to release you on bail pending your appeal. You go to the other court. But what is in South Africa? Under Article 35 of the South African Constitution, which we have read, Court Helicopter went to look for it. Once you have been convicted, the Constitution still, if you have an intention to appeal, the Constitution guarantees you that right. That right of you going home, waiting for your appeal, is captured in the Criminal Procedure Code of South Africa. Our Criminal Procedure Code in Kenya does not allow you to go home. The Criminal Procedure Code, Section 302 up to 309 of the South African Criminal Procedure Code allows you to go home. What does the law say? And you can see what happened. Once our guy was convicted and sentenced today, his lawyers made an application to seek leave to appeal. The court denied leave to appeal against conviction. There were 2 applications done. One, leave to appeal the conviction before the same magistrate. That was rejected. The second leave was leave to appeal against the sentence of 5 years. That was allowed. Once that was allowed, Malema was allowed to go home. He will now go to challenge sentence before the High Court. This is a very noble way, and I wish the Kenyan Parliament looks at that and amends the law. Many of the people who are sentenced are in prison. They make an application to the High Court for bail pending appeal. They have been sentenced to serve 3 years. The appeal takes 6 years. They finish, go home. Their application for bail has not been heard. So, what is the essence of this? If you check the number of people in prison, especially those convicted of petty offenses, you have been sentenced to serve 1 month. By the time you get the proceedings typed, you get them taken to the High Court. for appeal, the 1 month is over. Your application to be released on bail will be heard after 2 years. So Court Helicopter brings to you this critical issue that Parliament and the judiciary should now start giving this as an example. Has it ever happened in Kenyan courts where somebody has been sentenced and the sentence has been suspended? It happened at the Anti-Corruption Court, where the famous researcher at Cambridge, Dr. David Koech, after he was convicted, he was given a fine, and he was given either some 2 to 3 months or 1 month to pay. Failure to pay, he will be taken back to prison. He failed to pay. He went back to prison. The president exercised his power of mercy, and David Koech got freedom out of this. Do we see this as a new jurisprudence that Kenyans need to have in mind? So that anytime anybody has applied for an appeal, it should serve as an immediate stay. Let us look at the election law of this country. The moment a petition has been filed, that petition under the Elections Act provides as a stay. Why don't the Kenyan law be done like that in the criminal court? The number of people who are in prison who have appealed are more than the number of people who have not appealed. Many die in prison. Many finish the term of the imprisonment they were given before their appeal have happened. In the civil courts, there is what we call stay of the proceedings, stay of execution of the judgment. So that in civil proceedings, once the court makes a determination that Vivian, the house should be demolished because the house Vivian built, that Vivian's house is in Cyrus's house. Vivian makes an oral application immediately for stay of execution. The courts normally give 30 days, 90 days for Vivian to go to the High Court or Vivian to go to the Court of Appeal. Meanwhile, her building is not destroyed. That is the question. Malema made an oral application for stay of execution of the judgment and the sentence of 5 years. Malema today will be at home with his wife. Malema today will be at home with his political party members. Malema today will be with his children. The Kenyan law, Malema could by now have been shaved. Because once the sentence has been passed, you go to prison, you are shaved. This is a fundamental transition. And Court Helicopter has delved into that law. We need a law in the Criminal Procedure Code for stay of execution of the sentence until the appeal is granted. What is the historical basis of the Kenyan law? The Kenyan law looks at anybody in the criminal justice system as a wrong person. This is a colonial law. This was the colonial law in South Africa. Anybody who was convicted could serve until the appeal was heard. Until the Constitution of South Africa, which is more progressive in Article 35 of their Constitution as compared to Article 49 and 50 of our Kenyan Constitution. Look at it. The Kenyan Constitution does not guarantee such rights to somebody who has been sentenced. The South African Constitution guarantees those provisions for Malema to go home. What is our position from Court Helicopter? Our position from Court Helicopter is that we now have a national discussion that let everybody be presumed to be innocent until all the avenues of appeal are exhausted. If you look at Article 99 of the Constitution, they say for elected leaders, those elected leaders, they don't lose the seat until, even if they are convicted, until all avenues of appeal are exhausted. What does the South African Constitution provide? Malema will not fail to go to Parliament. Malema will still be a member of Parliament. Malema will still remain in office until the avenue of appeal are exhausted. This is a thumbs up for South African Constitution, a thumbs up for the South African jurisprudence, thumbs up for the jurisprudence that is progressive. For the Kenyan jurisprudence, it is 0 from Court Helicopter. They score 000. To South African, 100%. Wakili Dan Sanomari, always bringing you any topic global that has a bearing to the Kenyan legal justice and jurisprudence of this country. Keep watching, as still remember, we are still rolling our dancing Mubaba from South Africa, from King. We love you. Adios.